everything behind us, piles of dishes behind us, went,
Leave it at call.
flooded all the room.
We will.
But, I mean, it's all because that's phenomenal. You couldn't, I mean, just look at it, you know, it's right off. But it's going under there. But I didn't, we didn't get it done, I didn't, either one of us said, but we did, wore sea bands. Everybody.
Fancy meeting you.
Adam, I never think about it.
I don't see how you guys, he cornered me. Did he?
Oh, yeah, he cornered me.
Well, I knew when we stepped out, I said, I need to go back here and talk to Alice and see.
I'm gonna go over there.
I don't.
She wouldn't jump in and say a word. And then, well, yeah, because I told her that's when she came out, and she goes, right off the wind.
Yeah.
And I'm right.
Oh.
It's like, you know what? I've got nothing to say.
You know, this part that I put together, probably has changed. And we need to, we gotta figure this out. That water drivers. We took it out. We said it was so it's been response to that.
So we don't want to get this.
That is happening. We need to have all safety hazard for it. Just what it is.
Once we do that, I think we'll know I had a fire field. That's what I was wondering.
Is it gonna be required to have, you know,
I said, I called.
and
by the day,
have
I think,
they live
you know,
along
maybe it's not out there.
or is it gonna require them to drive
Everything I work good tomorrow, I get it. Well, my heart is soybean and some water comes out. And what's happened, he's running corn last 2 days. And, you know, he got big, big mixed in, I mean, don't let you do that. He got my, he got all of it.
How slow you have to go back and forth. Safety.
Think about it. Yeah.
I gotta let you get him in like a
We have to do pretty well.
Yeah, you know.
Flat visibility.
Got that now.
I can't do it. I can't. I mean, I'm on your side.
Slim kids, the shower rain before he,
No way.
north of Ohio River.
I haven't heard that. This whole, I mean, I'm not believing you, I just, that's new.
And the guy's been a customer of.
Says he's being good. So, and that's it, so it's good.
I'll feel sorry.
Got director time, $5.
Anyway, it's fine. It's all good.
Six.
I have a house staying there.
Nothing's wrong with him. All I can get out of it. We never said God, he's playing. Taylor said for us.
Are you excited about this upcoming wedding?
I didn't first one, ran over it. When they were this first name, we got all that time. It'd be probably 2 more, pretty quick.
That's how it usually works. At least you don't have to pay for this one, right?
Yeah, right.
Hey, Jeff, how are you?
Yeah, I never.
You know what I'm saying?
Yeah.
He's not going no more.
Well, yeah, you feel like.
How are you doing?
I
say, I must have your old address. You
Yeah,
had
let's
Jeff.
shop it, who's got that? I haven't had that, who's gonna get some? Yeah, mine is.
Right there on next line.
Yeah, you were sending it to my email address.
You have a lead or computer?
Oh, that's probably what it is.
Let's start all.
Mr. Jones.
Pledge, pledge, pledge. Jim, would you do prayer?
I sent an email to
You want to go and do prayer?
Jason Klein, he said, no, I'll be out of town.
Where's that?
Well, then
I
I'll
think
go.
Joe, you're
I'll say prayer. All right.
Yeah, that's the reason I missed the last meeting. I was when I looked at it, when I get this mail, I put it in my, I never got it. I was sitting there the next morning. I spaced it, I didn't know what to excuse.
We'll go ahead and call this meeting to order. Will you please rise? We'll have the pledge to the flag by Daniel Walker, and I'll follow by having a prayer.
I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Please bow your head. Dear Heavenly Father, be with us tonight as we go through this business meeting tonight with the Planning Commission and working with your land and trying to utilize your land as in the ability for us to make a living and also to glorify and take care of your land which you have given us as a bountiful gift. But give us wisdom and knowledge as we go through here, as we make our decisions, and to help us if we've got our shortcomings that we have. Be with us always as we do the endeavors of your work upon this earth and enhance your kingdom. In Jesus Christ's name we pray, amen.
Amen.
First, I'd like to have the secretary, which is our legal counsel, to please have a roll call.
Jeremy Sullivan. Here. Jim Day.
Here.
Scott Modlin. Urban Day.
Sure.
David Hoare.
Here.
Adam DeFour.
Here.
Phil Marshall. Daniel Walker.
Here.
Jeff Sauer.
Yes, here.
Do we have quorum?
We do 7 to 9 members present.
All right. Minutes from the previous meeting.
We distributed the minutes via email. I don't know if Karen McClellan, if you're on my email. Okay. We received no comments or revisions, so I would ask that you entertain a motion to approve the minutes.
Do we have such a motion?
Yes.
Adam DeFore has made the motion. Do we have a second?
Second.
Jim Day has made a second. It's open for discussion. Seeing none, we'll take it to the vote. All in favor of ratifying the minutes, signify by saying aye.
Aye.
Opposed, the same. Motion carried.
I'm sorry, who did the motion? Second.
Adam?
Adam, second.
I'd like to kind of reverse this order a little bit for the time constraints as far as for us to work with the ordinance in that, which seems to be more of a lengthy process. All the guests are welcome to stay, but I'd like to take the new business, which is basically the FAA and airport expansion. And I'm going to turn the floor over to you guys. Please introduce yourself. We usually give your name and address just so we verify who you are for minutes.
My name is Corey Harper. I represent the consulting firm Butler Fairman and Seifert. We, as of January, were hired as the airport's consulting firm to do the engineering and planning work for the airport project. My corporate office is out of Indianapolis, and I give my business card to the president for my full contact information. So, Wanted to come to you guys today. I put a packet in front of you, and there's extra copies on the table for a proposal for what would probably be considered to the area plan as new zoning instituted within the county limits outside of the 2-mile fringe of the city limits. Over the past few months, we've been working with the city and the city area plan to adopt zoning within the 2-mile limits of within the city and the city boundaries. The area here in front of you, you've got a smaller version of it in your packet. The area in red and yellow was adopted within the city area plan and the city passed ordinance. And that's city ordinance is 1468. It was adopted on September 9th. So that ordinance is currently protecting the airport and this red and yellow area within the city boundaries. The red area is for height restrictions, and that height restriction is for the proposed airspace of the new runway, as well as it protects for the current runway as well. So it does actually protect both the current runway and its current operations, and it protects for the future runway and when it's up and operational. Once the new runway is up and operational, there will be no changes required to this because the new runway actually protects just as much for the current airport as it does. So there wouldn't be no changes to this. We wouldn't have to delete any area out. So this would be the final product even once the new runway is open and the old runway is closed down. If you look at your map, there's a blue line that kind of shows you the 2-mile fringe around the city. Because of that line and because part of this zoning is actually outside of the 2-mile fringe, we wanted to come and present this to you guys as well. This is not an Indiana code. This is not something that's new. In 1986, when I was about 9 years old, the Indiana Code adopted Tall Structures Act, and shortly thereafter adopted the Noise Sensitive Area Permit. So in 1986, the Indiana Code has been enforcing height restrictions across the whole county. And since 1986, the state of Indiana has been enforcing height restrictions over Washington County, but without the participation of the local communities through the building permit process, without the participation from the area plans, there's no way to enforce that within the local community. The Indiana Code relies on the local community through the building permit process to be able to make sure that this is implemented. So when we came on board in January, shortly thereafter realized that the community did not have the proper tools to protect for what is already going on in Indiana Code. So we wanted to come in and go through the process, update the community, inform them of what was already ongoing. You have 2 copies, 2 different Indiana Code structures.
We need one more copy up here for.
Okay.
We need, Jerry.
No words. Whole thing.
I'll get it.
Wait, here's one.
Okay.
For Scott.
Oh, there's one more here.
Okay.
I got it. I had seen it up here. I didn't realize.
Still need
Mr.
one?
Clark stole it. The attorney stole it. Don't.
Yeah.
He stole the other copy. It's all the same. Everybody should have 2 copies of Indiana Code. One is highlighting the tall structure permit, and the other one is highlighting the noise sensitive area permit. And then the other one is a workflow packet that I put together for not just this community, but I put it together for other communities on a way to help work through the process to help make it as easy as possible in the area plans to implement this procedure. But these are Indiana codes. Noise sensitive permit is a permit that goes through. It doesn't say that someone can't build there. It doesn't say that someone can't develop near the airport. The yellow area here is a noise sensitive permit. That just makes anyone who has a noise sensitive type use, in other words, a school, nursing home, residential facility, multi-use residential facility, anyone who develops in this yellow area through the building permit process has to file a permit saying that they acknowledge the airport is there. It protects for the airport, it protects for the landowner. So anyone who moves into that area, develops there, can't later then come back and remonstrate against the airport and say, we didn't know the airport was here. Noise is a problem. I can't sleep at night. I can't facilitate my school. The kids won't learn, etc. Numerous noise sensitive type uses can't file a remonstrance against the airport. This is the Indiana Code. The Indiana Code is already requiring the local communities to enforce this type of procedure. You guys just didn't have the tools at your disposal, the knowledge at your disposal to be able to enforce this type of procedure. And honestly, the previous consultant should have done a better job of educating the community on this regard, because it's been going on since 1986. The red area here is height restrictions based on the airport's Part 77. which is this map here, which is their airport layout plan. This gives height restrictions around the airport of what could be developed in and around the airport for height restrictions. We're not saying you can't build anything in this area. We're just saying build to an area that won't be penetrating our airspace. You know, things like cell phone towers, things like water towers, those types of things being located in very close proximity to the airport are not necessarily a good thing. Height restrictions can be the further away they are from the airport, the higher they can be. It's a conical surface. It starts off very low, very shallow to the ground, and it builds out and up from there. Perfect example is out on the very edges. You could easily be 250 feet above the ground, and we would not have a problem with it. It doesn't mean you won't have to file. It doesn't mean you won't have to go through the FAA permit to airspace and submit an airspace on their behalf, but it will be you should be allowed to be approved. And a lot of it depends on the ground topography. You know, the higher the ground is, the higher the ground surrounding ground is, the more limitations it's going to have as well. Because everything that we're basing it off of is off runway elevation. So, wanted to come, meet with you guys today, present to you. We met with the the county council back in October, and they recommended that we come present to the county area plan and be able to get the process started within here. Even outside of this red football-shaped stadium dome that we showed here, this conical surface, there's also, Indiana Code also has a Tall Structure Act across the whole county. It's actually across the whole state. And it says that it's not to say that you can't get it approved, but you must at least submit. Anything above 200 feet above the ground must submit no matter where you're at in the state. So when you get to objects that high, if someone's going to build something 200 feet tall, they probably know the Indiana Code better than the area plan, or even better than the state, because they're used to doing it. Cell phone antennas, tall structures such as wind turbines, radio control antennas, those types of facilities are used to submitting tall structure permits. They're used to submitting that, and they know they have to go through the process. It's an FAA review, and NDOT, with the NDOT Office of Aviation, has a permit process that concurs with the FAA as well. So there's two permits that you would have to go through, and the workflow that's identified here kind of shows you guys the process on how that could be implemented. What I'm proposing is that my company develop ThinkMap, polygons, things that can be implemented into your GIS system to easily make this identifiable for your area plan. And we've offered the same to the city to allow them to make an easy process to identify when they have to do this. So if someone drops in an address and it pops in over here, and it's only 20 feet above the ground, I don't have to do anything. But in the same regard, they drop in a tower over here, or a 250-foot cell phone antenna over here, it'll tell them, yes, you have to file. So that's what I would suggest is we allow, because we have GIS department within our company, and we can provide the community with the easy tools to implement this procedure in a very easy and streamlined fashion, to not make it an overbearing procedure, because we know that if it takes a lot of effort, it won't get implemented. So our best way to protect for the airport is to make this procedure as simple, as easy as possible to implement within the local community. So, I'll keep it short and sweet. If I answer any questions you guys have, I would assume this may take multiple presentations within your guidance to get something developed and get an ordinance developed within the county and move forward from there. I definitely didn't expect to walk out here today with an approved ordinance, but wanted to come and meet with you guys and answer any questions you may have.
Question I have, since we, in the county-wide, we're just in the process of producing some zoning ordinances. And so there hasn't been a permitting process other than just regular building permits. But currently, the cell towers and the towers that's gone in prior to this establishment of this planning commission, those towers, are they grandfathered, or are they already regulated by the state in that fashion because of their height?
Correct. Anything that's already anything that's already built and already in place, it would be the airport's responsibility to mitigate if there's a problem. So if there's a problem that's severe enough that requires a mitigation, in other words, the removal of the object, it would be the airport's responsibility to remove those towers. There's a prime example is the old AT&T tower right by the airport has to be lowered or removed. And that's the airport's responsibility, and we're working with that company to go through those circumstances. but any new towers that would be adopted, any new towers that would be built, I would argue even without this plan being adopted, would have to follow Indiana code and have to go through the Indiana Tall Structures Act. But the only way they have to get it approved and to get it reviewable through the building permit process is for the area plan to adopt an ordinance and eventually the county to adopt the ordinance to protect it. But it's actually been argued in court that Indiana code would actually give you guidance above and beyond what the local community does and what the local community would have to enforce through local zoning. So, but to streamline the process, I would say you need to do something within the local community to be able to have a policy and an ordinance adopted so that you know what to review for. Indiana code allows for a $10,000 a day penalty for the state of Indiana to institute on a developer who does not file their building permits, who does not file the tall structure permit. So a developer who does not file the Indiana tall structure permit and then wants to build a 250-foot antenna out in the county, whether that's approvable or not, if they don't file, the state of Indiana can institute $10,000 a day. If that cell phone tower applied for a building permit within the local community and received a positive approval of the building permit and said, yes, you can move forward, you comply with our regulations, the Indiana state is going to institute $10,000 a day. My concern is who gets that bill from the Indiana state for the fines if the developer complied with the local regulations and filed and went through the process. My concern is that penalty could fall back to the community. And that's why I would encourage this type of ordinance to be adopted within the county and the city, which step one we did with the city. But I would urge the county to adopt similar guidance in order to make sure that policy is being followed through the area plan and the building permit process, so that those types of loopholes aren't met or that problem isn't encountered.
Who would review the permits to make sure that they were compliant?
The FAA has a airspace analysis that goes on to protect for the airport and their airspace, and the state of Indiana has a permit that it reviews for airspace as well. And the yellow area, this noise sensitivity, which most of that is inside the city limits, there's a small piece just outside the 2-mile fringe, that is actually just a state statute. That's not a federal regulation.
Right.
You're asking on a local basis?
Yeah.
Once the workflow that you pop in, once that permit pops in there, they submit, and the developer has to submit to the FAA for airspace review. So the only thing you have to do from the local area is to identify, does this penetrate the surface? So that's just it's just a notification, and it says, did you penetrate the height of this area? And if you're within this area, then they must submit.
Right, but who locally would determine whether it penetrates the airspace or not?
That's what we would do. We would give you the GIS maps. So if it penetrates, if it's in this red area, you would tell the developer, submit for the airspace. And the developer would submit through the airspace. This workflow, there's two workflows here. One is for noise sensitivity. So you have a proposed development. They check the GIS. The GIS is utilized to determine if the airport's within the airport overlay district. If it's not within this yellow area, if it's outside of that, you move forward. You just move on. You don't even have to file through the noise sensitive permit. If it is within that, then you file with the state. The state issues the compliance with the noise sensitivity, and they'll issue the permit, and the developer moves on. Same thing with...
The airport's going to provide an add-on tool for the GIS system, ThinkMap system, so that whenever somebody applies for a building permit in here, in this area.
In the red area also?
Yep.
Will it automatically tell you at that address how high you can go?
No. The FAA will. The FAA has an online tool that tells you whether you have to submit or not. The FAA tells you have to submit or you don't. What we've done is we have FAA guidelines, FAA regulations, and FAA online tools that makes it streamlined for the local community, where you don't have to be an airspace specialist, you don't have to be an aviation planner to be able to check and protect for the airport, protect for the airspace. That guidance is on the FAA and the state of Indiana.
So basically what we'd be regulating is just finding out whether or not they were in the red circle.
What you would be regulating is the enforcement of Indiana code, which would be anything in the county for things over 200 feet. And within this red area, it would do a penetration of 100 to 1 calculation, and the online tools would do that calculation for you. So anything in the red, you're automatically going to have to submit for an online tool and say, does it have to submit? And an online tool, what it'll do is the developer will put in their latitude and longitude and the elevation of the ground and the height of the structure. So you've got, latitude, longitude, and height of the ground is 850 MSL, and height of the structure is 25 feet. And say it's out here, it's well below the 100 to 1. The online tool will tell you no submittal required, move on. And they'll come back with that online tool and say, here's my latitude, here's my longitude. It tells me I do not have to submit. They're going to hand it to the building permit, to the area plan, or to the building the commissioner, and he'll take that and he'll staple it to the permit, and he's filed and he's moved on. If it penetrates 100 to 1, say he's close enough or the height is tall enough that he penetrates 100 to 1 surface, then he will have to submit to the FAA, and the FAA will determine whether it's a significant hazard, a hazard, or no hazard. And then once he receives that, and the airport through that process has actually notified as well through the federal regulations, through the FAA is notified, and then they have a chance to comment as well. So they have a chance to comment on the procedure and actually weigh in on the process to make sure that nothing is approved and built within that airspace that doesn't impact the airport negatively.
And you're meaning 101, like if it's 2,000 feet away, 20 feet tall?
Correct. It's 100 foot out and 1 foot up.
1 foot up.
Yep. And that's not to say that's what would be approved. That's just when you have to file.
Right.
If you don't penetrate that 100 to 1, you don't even have to file. Even if you penetrate that 100 to 1, doesn't mean that you won't be approved. It could very easily still be approved.
Gotcha. And you're looking for legislation on the county level that basically says that if it's inside that red circle, they need to find out.
To follow the workflow, yeah, to follow the procedure.
Before a building permit would be submitted.
Correct. And a lot of this area here, this yellow area here, just to kind of put it in perspective, this is 1,500 feet either side of Center Line. So this is 3,000 feet wide, and this is 1 nautical mile from the end of airport property. So it's a nautical mile, roughly 6,000 feet beyond the end of the runway, and 3,000 feet wide. So that's, if you look at that, that's where the funnel of noise, airport noise, is concentrated in that area. And a lot of that area is going to be owned by the airport.
Now, if I remember right, when you said that out in the county, a 200-foot tower has to go through this, it has to go through Indiana code permit process anyway.
There's a workflow already in place. Indiana code already protects for the airports. The problem is if someone builds and files for a local permit, the local permit could approve the building permit for that tower or that structure to go in, and it never actually go through the Indiana code to confirm it. So most of the developers that work on structures that high know that regulation's in place and know they have to submit. But their concern is that if someone's out of state, comes in to build, or someone who's unfamiliar with that process, were to put up a ham radio antenna, 140-foot ham radio antenna. There's no one in the room that has a 140-foot ham radio antenna, is there? But if they don't know that process, and they don't know that is it 140 feet? Yeah, but Lowell's got a pretty tall ham radio antenna. But if there's someone who puts up a ham radio antenna that doesn't know that regulation and doesn't know that process, it could be a hindrance to airspace. If they don't know that, if you put up something over 200 feet tall, you have to submit no matter where you're at in the state.
Okay.
And the closer you are to the airport, the lower that height gets.
So as long as we implement language, that triggers this mechanism, as far as this area, but also triggers a mechanism for any tower structure that's asking for the process to quantify that they've gone through this regulatory process, then that ought to take the liability away from us from approving.
Correct. And what I brought with me today is a copy of the city zoning ordinance. What the city zoning ordinance does, and we help prepare that. We worked with the city to help prepare it, but if you chose, I would recommend you guys do something similar to this. But what I would recommend, what this does is this really just refers back to Indiana code.
All right.
So really what you would be adopting is a zoning ordinance to enforce Indiana code, which is something you probably should already be doing in the first place. So, and it puts the liability off of your shoulders, you're relying on the state and federal government on their regulations so that you don't have to be airspace analysis specialist. You don't have to be airport planners. You just have to enforce Indiana code. And if Indiana code modifies or changes, which it hasn't for 24 years, chances are you're going to be safe in protecting the airport in compliance with federal guidelines. And the urgency of the airport to have this plan adopted is when they sign grant assurances, they actually sign grant assurances saying we're protecting the airport. Well, without some type of zoning like this, there's actually nothing to protect the airport from being hindered upon. And a lot of communities around Indianapolis have seen this happen where encroachment has gotten so close to the airport, they can't expand, they can't build. And then all of a sudden they get subdivisions complaining about airport noise and everything else. So because they didn't plan ahead and they didn't have zoning in place to protect for the airport, there's a lot of subdivisions getting built and the airport's actually having to go in and mitigate the circumstances, mitigate the problems.
Got a question. Utility companies don't have to get permits to put up utility poles?
Yes, it is.
They do?
Anything tall structure, anything that's built above ground, they may not have to file with a local community,
Right.
but they still have to file with they still have to follow Indiana code.
Okay.
Public utilities, even though they may be exempt from local building permits because of their right-of-way access and their right-of-way permits, are not exempt from Indiana code.
Right. But
And we went through this recently with some of the really high-rise stuff, like the 300-foot high-rise, like high-tension wires.
Sure.
And they said, well, we're exempt from local building permits. We don't have to follow local building permits. No, but you still have to follow Indiana code, and you still have to follow federal regulations. So they're not exempt from tall structures protected for airport.
But they would be out of our jurisdiction.
No, correct. Yeah, they would not actually file for you, but those guys know the process, and they have to follow the Indiana codes and and the federal regulations already, because of the assurances that they've signed from their airway rights anytime they're building. And depending on how close you are to the airport, even the local Duke putting up 30-foot telephone poles could be a penetration.
3,000 feet is,
Yeah, and when we're doing the airport relocation, we're actually burying the lines on County Road, on Drive-In Theater Road, because we don't want there to be penetration.
Right.
And depending upon, it's in southern Indiana, the ground topography itself, in some cases, could be a penetration to the airspace.
Sure.
Which is why we buy as wide as we are, and the swath of land that we're buying, the grading limits we do, are to help protect for that, so that type of penetration doesn't happen from the existing ground.
Gotcha.
We have a local radio station here,
Mhm.
and they've been in existence for roughly 60 years, 60 plus years. I don't know what the life expectancy is of a radio tower, but if they had to replace their tower, are they going to have to go back and start anew on their permitting and everything to put up a new tower?
Depends. If they go higher, yes. If it's an existing structure that they're just replacing one-to-one, no. And there's actually guidance within the Indiana code that says if it's shadowed from the runway or if it's shadowed from the runway environment. So in other words, if you have a 150-foot tower around you already and you want to put a 60-foot tower beside it, that 150-foot tower is already there, it's already approved, as long as it's approved. Then the lower object, the shadowed object, is actually not required to submit, as long as the first object was approved. So I guess the grandfather effect is fine if we don't want to. If the airport wants to mitigate the tower, they would have to go and mitigate that existing tower. But if you want to build a new tower and replace the existing tower, as long as it was approved, then you do not have to refile. So, but if that original tower was never approved 60 years ago, if it was never approved, then yes, they would have to file. Other questions?
So basically, the way I see this is we're not creating a separate zone per se, the kind of new language similar to the dam situation that we're approached with.
Right.
These are things that can be implemented into the draft of the existing ordinance that I don't know how quickly we can work out the language in both situations, but as we near completion of this agricultural regulation.
Yeah, I want to draft language, that language for the city. And is that a copy or?
This is a copy. This was the unsigned copy, but this was Mr. Wright's final copy that he presented to me upon its final release. And what I did is I attached a different graphic to the back of that. When the city adopted their zoning, they adopted the zoning with the exhibit similar to what you see here, but it did not have the blue fringe around it for the 2-mile buffer around the city. So I've added that to your exhibit, so it'd be very similar. but I added the blue line to your boundary so that you could easily discern in a paper format of where the boundary of the 2-mile buffer is and where the actual city buffer is at.
Okay. All right, we'll take that under advisement and then,
Okay.
is there any questions for the plan commission to address on that? We'll take a look at this, we can work it out and implement it into ordinance then, I think.
Yeah, I'd be more than willing to come back and meet with the area plan again, answer any questions you guys have and help you work through it. Like I said, it's in the best interest of the airport to have this protective. It's as well as a community, you know. Sometimes good zoning ordinances make for good neighbors. So it just keeps from any questions being asked later without guidance.
Seems like John comes in here to work with things up in the air and sometimes things that are low too, because he works from dams to towers.
Oh, yeah. Well, if there's anything I can do, I mean, I'd offer my assistance to come down, meet with you guys again. I'm down in the community once a week almost already. So more than willing to come down and meet with you guys, talk about it, work through it. You know, we want to be a partner to the community to help develop this type of stuff and help protect the airport. So if there's anything we can do, any questions we can ask, make presentations at future meetings. If you want to have a public you know, ordinance, you know, public presentation, glad to sit and meet for that, for an advertised agenda item. So just let me know how I can help and what I need to do.
Now with this ordinance here, we'll probably have to have a public hearing on it. Okay.
Yeah.
Travis?
Do you know, moving to the west, the farthest point that's shaded in red, do you know if any of it leaves Washington Township?
I'm not sure.
I would look.
I know it doesn't leave the
map, it's
county.
farther,
I know it doesn't leave the county.
well, yeah.
Oh, it, by this
The
is
furthest
Vernon.
point west is, looks like 550 west. What town, does anybody know what township that's in?
I believe
That'd be in Vernon.
there's a piece of it in Vernon, I think, Travis.
Yeah, Vernon's in Vernon. By this map.
It goes past that,
It looks like it touches just base.
What the section line is.
Which
15.
It looks like it just goes up, right up to County Road 550 west.
I think there's a piece of it in Vernon on the
It
west
does
end
appear
there.
to be.
Shepherd's on that.
Yeah, it looks to me like it goes about 200 feet in the township.
I can't make out the section numbers on that plat, maybe.
You see it on this any better? Just a bigger scale. See, it's right here at 550 is right where it comes in.
Have you got that on your, Corey, you got that on your phone?
Not this copy.
18, 19, 20.
I have it in GIS at the office.
That should, yeah, that's
That's the section line.
that's the township line right there. So it goes into Vernon Township by a half mile at its most extreme point.
And actually, if you look at it in that regard, Indiana Tall Structure covers the entire county. So even outside of this football stadium shape, the tall structure of 200 foot and higher would cover the entire county.
All right. We've got the sample ordinance from the city in there, the copy. We'll take that. Anything else? Make sure Tom gets that to review it and stuff.
And I can email you a copy if you need to, give you a workable document, a Word file of it, make it easy.
John, you guys have anything else to add? No?
No.
Moral support?
Here.
So, why don't you take this ordinance in there and just take it to the undertone of getting down for your dams and we can.
Well, I might do that.
Just copy it, All right. If not,
I'm waiting on a definitive description of the inundation area, so.
Definitive definitions
Of
of what?
of the breach inundation area,
Oh,
some way of,
identifying that floodplain. Okay,
so.
okay. All right, if not, we'll move on. We'll go back to our old business.
Thank you, guys.
Which
Thanks,
is
Ezra.
basically our zoning ordinance that deals with confined feeding. Bring it up to date on this last meeting, we had some people present and some not, and I do want people to help me out and verify, but we kind of identified scenario 1B of Farm 2 as being a kind of a project. Lee, I've got it circled, maybe I've got it wrong. And you know, have you got anything in your notes?
1B.
1B.
That was voted on.
Okay. And then, basically and then if you don't have a copy of this, we'll try to get it to you later, but it weighted more points in the point system, dealing with, instead of section density, we're going to talk about population density. And it's defined at half mile square of the facility. And basically what it did, it took the 0 to 5 quantification from 50 to 60, 6 to 10, and took it from 30 to 40, 11 to 17, and took it from 20 to 30, and from 18 to 23, it took it from 15 to 25. So we just gave more weight for a less populated area. Going down, separation from house, public use facility and church. We had the minimum standards, and then we worked with the more than 250 feet, moving it from 40 to 50 and from 60 to 70. So we gave weight for 250 and 500 feet. We had thought, and bring me back up if I'm telling you wrong, we did not think that adding more than 750 feet in weight of points was going to gain us anything. In fact, it was actually going to do worse. It was going to take in land that wasn't necessary to be taken in. So we weighted those two items.
What was the second one in church, schools?
For a separation from house and public use facility church, we weighted more in a category for at least 250 feet more. We moved it from 40 to 50 in points. And for the 500 feet, we moved it from 60 to 70.
I was just trying to write the category.
Yeah.
Public facilities.
Yeah.
House, public use facility, church.
And then we left everything else the same. Now with that, you'll have to change. What did we decide to do on minimum points, the freshman minimum?
220.
We were still saying with 220 for the minimum points, even though we weighted those heavier, right?
You wouldn't want to change it if you raise the minimum points, if you're raising your weights, you've got a wash.
It will be a wash on that. Okay. Just wanted to verify that. But that's where we're at with the score sheet using scenario 1B. That was 1B was a scenario. Okay. Now, does everybody have the ordinance? If you don't, I've got the current ordinance that was presented to the commissioners, that was sent back to us. I talked to Jerry on the phone the other day, and I told him 701, but it's actually 702, but I probably figured that out. All right. But I did that from the field, too. All right. Let's go to 702. and that's where this needs to be implemented. 701.2. I have some extra copies of this ordinance, if you want, if anybody from the public would want one to refer to. I copied some extra ones. Max?
I've got one more March version.
We pulled up by April.
Is this it, the one that?
Yes.
Yeah, this is April 18th, is the date of the email.
I don't have an attached email, but just,
All right, I've got this copy if you want to work with this
would
copy.
you pass that down, just so I'm,
All right.
we're talking the same.
Can I scan this in and put it online?
Yeah, that's fine, because it's already been reviewed once before. There's nothing that's been changed in that, so that's the original that was,
Yeah, that's just a proposal.
that was the one that was sent to the commissioners that they denied.
Right.
All right, 7012, for one, we have to go in there and we have to make some definitions. Because we've identified AFOs, CFOs, and CAFOs. And if you want to go back and, it's
Definitions page, that page
Yeah.
7. Page 6.
page 6 is your definitions. All right. Where we have confined feeding operations, I'm making a recommendation that we cross out confined and put animal, and put the AFO synchronous behind that, change the language from confined to animal feeding operations, because this is our tier bottom level where everything starts. So this is our minimum level when we do our description down below, dealing with the cattle, calves, swine, horses, sheep, turkeys, laying hens, chickens, and all that. This is actually the reason for that to change that, because this is different than state requirements for permit, because we've got lower standards as far as where we start on the permit process. And the underlying factor that starts the mechanism as far as manure load starts with 18,000 turkeys. So that's your base point where everything is multiplied off of 18,000 turkey manure load. That's how we calculate it. So whenever you do that, we change that, and then down below that I have added lines in there, and I'm just doing this for recommendation. Then we say confined feeding operation, CFOs. Confined feeding operation, or CFO, shall be defined as a feeding operation regulated and permitted by state regulation and permit.
So that's for CFO.
CFO. All right. CAFO. I have said that this is a proposal. Concentrated animal feeding operation, CAFO, is a confined feeding operation, or CFO shall be defined as a feeding operation regulated and permitted by state and federal regulation and permit. So that is state and federal. That defines it differently than CFO.
Is that how the state defines it differently also?
It's by animal sizes, but it goes into a federal permit, an NPDS permit.
Okay.
That's basically the biggest difference. It goes into an NPDS permit, which has a whole different gamut of record keeping that goes along with it. But for simplicity, I thought that was the easiest way to define it. If you want to change that language around, you can, but you have to expand the definition. Okay? So that makes the definition changes. Then we can go back to our page. Back on. Page.
You also wanted to, while we were in definitions, you wanted to.
Oh, yes.
define homestead.
All right. I did not define homestead, but as I was talking to Adam, we do need to define homestead. Now, Jeff, homestead, how is it defined by the county as far as property taxes, just for reference?
I don't think that this would have necessarily be defined the same way, because we define the residence here.
Those who appeal for a homestead exemption according to taxes have to claim that as their residence,
Primary residence.
as their primary residence.
That's where I'm going.
Right. But here's the thing,
Okay.
this exemption is for points in the point system, and it's going to require its own completely different definition.
All right.
According to, it's for use in this
I know.
piece of.
But still, primary, is probably keep them coming.
Yes, primary probably needs to be in there, but it's the AFO, CFO, or CAFO, the owner and operator of,
That has to be their primary residence.
right, the AFO, CFO, or CAFO has to be their primary residence.
Right.
Well, would there be any conflict in saying that the residents on that property shall be the tax parcel for that property shall have a homestead exemption?
No, because it could be somebody else's, if you're using the actual language from the homestead exemption for taxes. Because it could be somebody else living in the house, and it could be on the property, and whoever it is could be claiming it as their primary residence. And if you're building a chicken house on your dad's farm.
Unless you want, but unless you made it that the applicant themselves shall be the one and the same as the person claiming a homestead exemption.
I see where you're going with that, that is kind of a clever way to put it.
Well, I put a lot of scenarios together. Say that a father or mother and father own a piece of ground, and they allow, or they've got a son or daughter coming back, and they put an operation up on a piece of property. That son or daughter may not own that ground, but the operation's been put up, but they're owning and managing it. I almost steered to go back to immediate family. Now, I know that opens a whole can of worms, but the homestead is either primarily owned or immediate family.
Well, what he's saying kind of takes care of that. He's saying that if you word it as to where the applicant, whoever the applicant is, and we're going to assume that the applicant is the proprietor of the farm,
Right.
their home, that they claim their homestead on, exemption on with the county for tax purposes.
Okay.
Two reasons that we might not want to do that. First of all, there might be a scenario that we're not thinking of where they should be awarded the points for our purposes, because the goal is that to further the notion that someone who operates a facility and lives there is more likely to safeguard against the nuisances that might affect neighbors than a distant owner-operator. And there might be scenarios where someone doesn't qualify for the homestead exemption or doesn't elect to take the homestead exemption. And but still meets our purposes. So that's objection number one, if I have a specific scenario, but there might be a lease arrangement where you lease someone a farm. I don't know if they can still take a homestead exemption on a lease or not, but see, but they can lease the farm and the home, and they're the operator living there, and that meets our purposes, but they don't qualify for a homestead exemption. So requiring that, it's an easy way to tack it on. Second of all, what if they change the rules on homestead exemption? That may or may not change us. So we can look at the language from the assessed tax on homestead exemptions and incorporate some of that language in, but I would hesitate, just like when we had Dr. from Purdue, Hubert, when we had his model, instead of incorporating that by reference into our statute, you don't have any control over if that gets changed or tweaked or anything like that. That effectively changes your ordinance without any knowledge locally. We didn't change it, but we incorporated by reference that outside measuring tool. Does that make sense? Whether it's his computer model for distances and winds and all that, or whether it's the state legislature's determination of who and what and how you qualify for a homestead exemption. If there's a change on that end and we incorporate that by reference, they've just changed our local ordinance without our approval and maybe without our knowledge if we're not paying attention. So if we like that language and we like that, we even want to use the word homestead, because once again, we just talked about getting away from the use of the word CFO and confined feeding operation, because our definition differs from the state's. If our purposes differs from the state in the tax assessment realm, do we really want to use the word homestead? Or, we just kind of toss that about. We all, as a quick reference, we all knew what we were talking about, but now's the time, I think, to discuss it. I think we come up with our own definition to meet the goals of what we're trying to accomplish, and that is to give someone credit under the belief that someone who lives next to the operation that they operate will have a greater incentive to abate some of the things that create nuisance to neighbors that we're trying to get abated or cared for. Because if they're subjected to it up close and personal, the theory is, right, that they'll take care of it more than a distant owner. So why don't we just come up with our own language? I feel like I'm not making.
All right, well, I mean, we can define it in there. We can say, and like I said, this is our own definitions in there. I try to refer back to what the homestead was so that we had something that was very similar to what you could understand. And I think that some of the language coming up there is a primary residence. So, if an applicant is the primary resident that we classify as a homestead, then it qualifies.
I think there's a rule now on homestead exemptions that if you can deed a 100th interest in the property to whoever you want to have the homestead exemption, if they're eligible, and they can file for the homestead exemption if they have that 100th.
So we probably need to stay away from that type of language, in there. So you want to change homestead, this is how to do it. Okay?
I think you could just be plain and matter of fact about it. Operator living closest to facility.
Okay? Give me a name and make a definition.
You know what I'm saying? Operator proximity.
Or just, on-site residence.
On-site.
Just give them credit.
Operator on-site residence exemption.
The operator residency exemption or something.
Yeah. But then define it as.
And we can use the word homestead. I'm just saying that if we.
Right, but using.
We don't want to be.
Right.
We don't want to be confusing to people.
We have to define it though.
Yeah.
Because we've used it as one of those points, so it needs to be defined.
Yeah, and I think it would be better to not even use it probably, considering that, I forgot completely about that, but you can put anybody's name on the deed, and if their name is on the deed, they can apply for homestead.
All right.
So you could get around it any number of ways by doing that,
And that would have to be the primary household, or primary residence, primary
Of the
residence
operator,
of the operator.
owner/operator.
I thought we talked about this in the previous meeting, I thought it was, that where they have to live there, spend more than,
That was classified residence.
That was in residence is already,
okay.
Yeah, that's where that,
There you go. Oh, I think we could incorporate the definition of residence into this.
Correct.
definition.
yeah.
Let's see what we did with that.
Well, I mean, if you just say in there, yeah, any one or two-family dwelling or portion thereof, including townhouses, that is used for human habitation, for living, sleeping with eating purposes, or any combination thereof.
But along the same lines,
Well, if residence is already, residence is already described, it's already defined here. So if you use residence in another definition in the definitions, isn't that still covered under this entire ordinance, under what residence is?
depending on whether or not you use quotation marks throughout, so
Well, if you did, I mean, wouldn't that cover it?
yeah, except do we want to do that? Or do we
I
want,
define it here.
yeah,
I put it on the line.
do we want someone who only lives there 6 months of the year? Do we want to give them full credit as opposed to someone who's there year round? Is that sufficient?
I don't see how anyone would run a CAFO and not be there all the time, a full-time job.
Well, they could have,
I guess if you have
Hands
another
running,
house
you know.
that you ran off to, the rest of the time you have to start.
All right. So do we need to tweak this language now?
or we could probably come up with a draft outside of the meeting, you know.
All right.
I could probably work on that with
All right.
something.
Well, we understand the concept.
Yeah, we all understand what we're after.
All right.
It's just I want to clarify before we move from that topic, is 6 months out of the year, is that sufficient? Do we want,
Well, it's sufficient for a resident.
And we've said it suffices for residents.
but residence is used in what context in this?
To describe what a family dwelling is.
But how does that come into play in our ordinance? Because it might be for a completely different purpose. In other words, when we talk about density, what about a house that's occupied 3 months of the year?
It won't qualify.
Okay.
A hunting lodge won't qualify, those type of things.
That was the purpose of defining residence here. But I think that's a reasonable requirement as a residence on the site too. Because I don't think somebody's going to have a house there and be able to not live there all the time.
If they've got hands that live on site with them and they aren't full-time
Who's going to
operators.
watch that anyway? How would you ever know? You know, we can only, I think that's one of those things. A residence is a residence.
Okay, I think we need to implement that residence language into this, but we need to, on-site residency, whether you call it homestead or what, or however we change that, it's an on-site residence. Okay? All right, back over on 701.2.
We're just trying to figure out where to stick this scoring system.
Correct? I have done a few things in here on 701.2. I struck out CFO, and I had AFO, CFO, and KFOs, all on that line. And then I forgot to mark that one down to 701.2.1 CFO. We need to, I went down, I had it A, B, C, and D. Okay? A must be located minimum 400 feet for AFOs.
Right.
Okay? B must be located a minimum of 600 feet for CFOs. Is that the correct distance? All right. And C must be located a minimum of 750 feet for CAFOs. Then I went down to D, and AFOs, CFOs, and CAFOs must receive minimum score on score sheet and all setback and additional requirements must be met from a minimum score sheet.
Are you putting the score sheet right there?
And it's someplace in there. Then I left it. E open for, as a continuation of line, you know, for the distances from an existing off-site residence public use. I wanted to quantify and define those minimum setbacks first, even though they're defined in the score sheet.
Where were you gonna move B, C, and D that were already in there?
I just kept moving down.
Okay,
Everything else moved down.
okay, it became different
Yeah,
letters.
become different letters, I've just moved down. Now, maybe I want to redefine the setbacks on the individual one, so it's referenced not only in the score sheet, but actually in the document. I think that's important. And then, how do you implement this score sheet?
I think we can attach the score sheet as an exhibit, but I think in the document itself, you need to go through line by line and explain how it works, rather than just reference the score sheet, because I think it needs to be spelled out in complete sentences that points shall be awarded as follows for, going forward. On-site operator residency, so many points for, go through each category, and then go on to state that, certain abatements and things like that, and then at the end, say that a minimum score of 220 must be met for approval.
Okay, so instead of setting a minimum score sheet, put the points numbered right there.
He's saying actually write out all this instead
All
of
right.
writing out a score sheet.
As a attachment or here?
Both.
All
I
right,
think it here is mandatory. I
Right,
think the language needs to be
Yeah.
in complete sentences in the
yeah,
ordinance.
I think so too, and then the score sheet can be like an appendix that is
As a
attached.
reference.
Yeah, as a reference.
Kind of like the checklist on our
Right,
building, or
Exactly.
our subdivision ordinance.
something, yeah.
That's not a part of the ordinance itself. It
It's just
doesn't-
something somebody can
isn't-
look at to see, right. Yep.
all right, that'll take a little language.
Yeah.
Mhm. You might be using some language by the time you get done.
Okay, and then in this part, so that would be the same, this would all be in this section of 701.21, right? Point 1. This would still be, that language described in the score sheet would be in reference right into this.
That is developmental standards, so yes,
All right.
I don't see why it would not be in that.
Additional standards is something all different than that. All right. All right, that's gonna be a lengthy section.
I'm happy to work with you on that.
All right, well, Danielle and I, we've worked with some of the language back and forth as far as with these different scenarios and stuff. So we do need to, that could be a couple pages. Okay, all right. Now, help me out here. I did these reference A, B, C, and D to try to identify the distance requirements for the different definitions of operations. And then D, I tried to go, which is not referenced in there, because I moved everything from A, I moved down in there. But I still left the one on, that was an A from existing. Now, I put that as an addition, to, all these are different aspects of the different operations, the 4, 600, and 750, and then the score sheet. But it's still referenced back to the same language from an existing off-site residence. because that was the point of measurement that we had on it. The point of measurement was from an existing off-site residence, public use facility, or church. This shall be measured from the closest edge to the nearest, there's that CFO again, we got to change that language in there. Structure, to the nearest wall or house, public use facility, church.
And I also think structure, AFO, structure, we need to, I need to define that too, but maybe not put in definitions, but here suggest that there could be a building that's housing live animals, and then 50 yards closer to the nearest residence is a compost. We need to make sure that we meet any source of odor, any operation that's a source, any part of the operation that's a source of odor.
It says all manure storage structures, animal confinement buildings.
Including within.
Okay.
Yeah, it says all that.
Okay.
That's not just an actual.
Well, okay. When you read it just now, I thought.
All right.
Yeah, it defines it for right before that, actually.
All right, so your language that used to be B is F. This goes back to 3960. The only thing I changed is the CFO. I added AFO, CFO, and KFO. Every place there was a reference to CFO, I put those 3 acronyms in. Okay. Same thing down what used to be H, no, used to be D, is now H. Same thing with the acronyms.
Are you saying that's been changed here, or that's in your proposed?
That's what I'm proposing.
Okay.
Right there. So language, describing the score sheet should be added into this. In any particular area, close up to the front, behind the minimum standards, because we have another minimum standard to be added into this, and it's water. Water was pulled out of the original of our
Score sheet, yeah.
We said that had to be a requirement.
But I think what we said had to be a requirement was that they had adequate water supply for the facility,
All right,
because that was just a given. You know what I'm saying? Obviously, you wouldn't be able to do this without it.
well, in the public hearings and stuff, and the people that had testimony, water was an issue. And
Based on not knowing what would happen, and my understanding from the follow-up was that when water companies are contacted, is it basically they won't run water to a facility if it's going to tax the residents of the area. In other words, I've been told that certain water companies have said, no more. We're not going to authorize any further hookups from our supply to any more operations because we're at capacity. Am I wrong in that
I
understanding?
heard people saying that out there, but they weren't from the water company.
Okay.
So, yes, you're 100% correct. I heard people saying that.
all right, so
So I guess my thought was that might be taking care of itself because the water companies have.
it was at the conclusion.
But you know what, it probably wouldn't hurt.
Yeah, I think it would not hurt to have language in there that basically just says that they have to provide proof of a adequate water supply for the proposed facility. And that means that either the
Water company.
water company knows what they're doing and says, knows they're not going to try to hook onto the house meter and run the thing, you know what I'm saying? And has, approved
A separately metered.
a separate meter for it, or they have a well that will provide that many gallons per hour that it requires some of these things. And we can define that, we can actually say all that in there.
Okay, so you want to insert a line in here that says
It could
proof.
even say that they were required to obtain a letter from the water department, from the local, whatever water municipality they're using. And, you know what I'm saying? that they understand that what kind of operation and what kind of, is being proposed and what the water usage is, and that they're okay, saying that they'll provide the water. And that should cover our butts on, people coming in here saying, oh, I've got no water because you guys let us, you guys let somebody put, turkey barns in, off the street from me. If the water company says, hey, here's a letter that says, you're putting turkey barns in and it's okay.
Can I fair to say to go ahead down to I then, and put that as says proof of water quantity? And then, the water, either water company or private well verified, and some type of mechanism.
Or shouldn't that go under additional standards as a separate, because the things above are about varying of distances, and this is a up or down.
Well, okay.
You know what I mean? These additional standards are up or downs, aren't they?
All right, so move it down to 7012.
That's what, I think that's where it needs to be.
All right.
Yeah, I agree.
Okay, so we'll put that, move that down for additional standards. And like I said, I went through here where CFO was referenced, I went AFO, CFO, and KFO. Reference line. All right. That's all I did with that. Anybody else got suggestions? Danielle, I know you wrote some things.
Yeah. Sorry.
That's fine.
I hope you're planning on sharing those with the rest of the class.
Yes.
I guess some of the things I wondered was, and it might be covered under, when we look at the point system, but do we need to identify or define what tilled, pasture, and forested meant? We talked about that a little bit, about how long something needs to be in pasture before it's pasture, how long it's tillable ground, that within that practice before we give points for it. I also think that we need to, at some point, I define or put in there what EPA and an IDEM violation is. We've talked about it amongst ourselves, that it's just a water quality issue.
It's time we thought you didn't like us.
Well, not today. I just figure we need some sugar. I need some sugar.
Thank you, Rhonda.
You're more than welcome.
God, that's everything they got up there. Yeah.
Section density, I think, I don't know.
One thing about the water that concerns me, I don't know how many of you dealt with local water companies, but that's given them an awful lot of power, and they don't always deal even-handedly across the board. And they don't have to. So, I don't know.
Well, I don't know either, Irvin. I know that public testimony, we tried to relay off the comprehensive plan. We tried to take public testimony and hear what the public was concerned about. And of course, odor was one of the big things, setback. But then there was a lot of discussion on water.
A lot of people were concerned about being short on water because in some 100-degree July week, the cables are going to be sucking the pipeline dry. And I agree that that is an inordinate amount of authority and control to give to the water company. It's not going to regulate it at all. I mean, there's an elected body that regulates that. Which I mean, government is evil, but for the most part, that to have to be represented by, the people who constitute them. But, and the water company is a business basically, but there has to be some kind of checks and balances somewhere, because if someone is putting in 2 boiler houses, for example, we're talking a couple thousand gallons a day actually per house. That's a lot of water.
It is a lot of work.
And if the water company can't do it, now whether they're telling the truth or not when they say they can't do it, I guess we're gonna have to leave some of this up to, that, I think that'd be a really good place to start, is knowing whether or not the water company thought they could do it.
That's true. But I think at some point, we could go back and challenge what they're telling us and make them prove it too.
Yeah, I guess wouldn't that just fall on the operator?
It would be a burden of proof by the operator, I think.
But by what standard do we judge that? I guess that's where this really, because the questions that came up that I recall from the public hearing is, what if there's a shortage? Who's gonna get water first, me or someone's animals? Well, when they go to look up initially, they got no way of predicting the drought that's gonna occur 3 years down the road, and by what standard of proof do they have to present to us to say there's adequate water supply? But there's no way to measure
He
that.
makes a very good point there, because if we define that in this ordinance and okay it based on what somebody says, and somebody runs out of water, does that put any liability on it?
I just don't, that's where it goes back to the whole water company approval thing. I think they're as concerned as anybody else. So I don't know. That's where I thought the conversation with the water companies were gonna go.
I think that probably they're going to go on Mrs. Smith down the road where she has enough water pressure to take a shower at 4 o'clock in the afternoon or whatever. And I think they're probably going to be more on water pressure than they are volume of water.
I think it would be unrealistic to put, say that you got a mile line in there and you got a 2-inch line running down there to a resident, and then all of a sudden you think you're gonna put a animal feeding operation, 3 turkey buildings on that same line. And think that that's gonna be adequate.
Something else I'd like to point out here is that I know for a fact that Tyson requires separate meters from your residential meter. Tyson won't hook up, they won't let you hook up to your residential meter. If you live on a farm and you want to build chicken houses, I don't know about part of that, the other people.
I think they require separate also.
Yeah, but I know Tyson requires that you put in another meter, so the water company's obviously gonna know what's going on, if you're putting in a meter for a Tyson facility, for a part of that facility.
It's more of an engineering thing on the water, to tell you the truth, when it comes up, whether there's enough volume, pressure, and that, and for us, for a plan commission, unfortunately, we're trying to plan for proper places for placement in there, and we're dealing with a lot of different variables, but this is one that we don't have much control over,
I don't know if we want to stick on that, whether we're okay or not okay.
And haven't we lumped several concerns under one category of water or water supply? Because what I heard being said in public hearing is different, was several different aspects of water.
whether it's quality, they talk about quality, quantity, whether it was, whether it was
Distribution
rural water
and
or well. There's the same concerns that you have in certain areas where there's water, but it's scarce.
Well, water quality, we can't regulate
No,
water.
water quality's out.
We don't.
Yeah. Okay, so how do you want to handle water?
Let me go back to, I believe someone was going to talk with the water companies, and when we reported back, I wasn't sure that he didn't mention that, but it's like as far as what they said, I don't have a grasp of what their approval process is. And do they address it? To what extent do they address it?
I know of 2 instances where East Washington Rural Water had committed to allow somebody to, told them that they could go ahead and hook on. Well, before they could get hooked on, they backed up and said, no, we didn't really allow you to do that. So,
But the fact that they will or will not grant permission suggests to me that there is some standard by which they're making a determination.
yeah, I think it's arbitrary. I think
I don't know, well, I don't know.
It's almost self-regulating.
In both of these cases, they came back and required the individual to lay larger line from the main line back to their facility before they would hook them up.
I can see that. I can see that. We can't jurisdict it. Because if they say that you can go ahead, but they make and that's an engineering requirement to allow enough pressure back there.
Well, even if it's not engineering, it's a customer service issue of whether or not they're going to allow.
Yeah, there was no engineer involved in it.
Yeah, they just, whether or not they're going to allow such a drain on their existing supply, given the internal infrastructure that they've got in place in that area. Is this something that we can allow because it goes to their customer base? And that's kind of their decision. You know what I'm saying? The concerns I was hearing was what happens if there's a drought and someone with all the needs of these livestock, are we going to water them to our detriment? Do we get it first and then them, or if someone's got to go without water, et cetera, et cetera? So we start talking about a backup water supply. But I thought, well, if we're in a drought situation, I don't care if someone's got a well. Isn't it fair to say that if a source of Salem's water supply is depleted, the wells will similarly be depleted? And so does the existence of a backup really address our concerns there? And I'm not trying to throw a wrench in any spokes, I'm just trying to think, what can we and can we not do? Is that not perfectly valid?
I've got here proof of form. Proof of form.
Yeah, adequate.
Proof of adequate.
This is my question. From your point of view, if we put in a proof of adequate water supply, and they prove they have adequate water supply, and we approve the permit to do this, and there's a water shortage, that cannot possibly come back on that.
Yeah, see, and I'm going to disagree with our engineer, with our guests to the extent that there be any, I mean, there are certain immunities that exist in the code for, and our discretionary, what kind of discretionary function they would have. So I don't know that any liability would attach, but it's certainly from a public relations standpoint, regardless of what the legal liability. Sometimes I encourage elected officials to don't think about it in terms of legal liability, think of it in terms of human loss to the community. We're just as concerned about if there's a shortage, have we just allowed an operation to affect human habitation just as much as they're concerned about it, regardless of what liability they have. It's the same issue, I just say it in a different way. I don't think that when we make decisions, I think there's an immunity.
An example that comes to mind of what I'm kind of concerned a little bit about, and that is others used to inspect all the wiring in the house before they would
are tied to a certain degree, along with TNT. All right. Okay, let's go back to Danielle's comment. We need to define ID violation because we've got it in here as an ID violation at the amended points. We want to make that a water quality violation instead of a clerical violation or any non-clerical. Okay.
I can cover the water quality. I have the email. I have an email that he specifically said this is how it is. Is that I have an email.
However, I get it, it's exactly.
I don't know if that's a email.
All right. Property definition, till.
Tilled, I would say tilled would be, that would be cool. Not cool, but. I would go, I would say it's 2% of that way. If you can put it way back, you have to rest and see it there. I would say it is, you just, the definition, I would just say it's curved at all. It's curved in pasture, or curved in road property, it's curved in field.
I would think that you would define it the same way that it's defined for CRP now. It had to be tilled so many years out of the last 5 years
Is
or
that
out
how
of the
we do
last.
that in 5 or 7? I think it was 5 or 7. So that would be good. That would be, I would just say that also.
So, we're all in water. I'm gonna refer that to US. Right? Danielle, anything? Okay, all right. Odor abatements, we had that in different classifications, and this is the difficult one. We've got a stage 1, 2, or 3 level, and Danielle got a really good example, to work with. And I haven't had time to decipher them, in the different things. We got liquid manure, dry manure, and he's seen that too. We still want to run with 3 categories. We got in the score sheet from 100, 50, and 25. 25, I would classify as nothing more than feed additives. Right, diet manipulation, feed additives. I am putting in the one from Iowa State. The one that's kind of a tier of boxes underneath. I don't know if you got this, anybody got that reference?
Yeah, I've got it right here.
Okay.
Part of it.
Yeah, I've got it somewhere.
You haven't done one off of this concept.
Do this.
At least I have a few minutes.
Cities, airport language.
I ain't got that.
It's for Tom. It's a city airport manager.
Okay, now don't look at the other side.
And I would look at strategy one as being one classified as biofilters. And as far as the perimeter greenery,
I'm lost.
Iowa State. I'm trying to work, we got other abatements, 1, 2, and 3, and I'm trying to give a kind of a definition of what we would look at as a level 1, 2, and 3. I said that I'm making a recommendation that level 3 is the lowest end, and that would be diet formulation. And say that the buildings are all bare, all the way around, minimum requirements in there, diet manipulation, you know, for odor control, if they show that they're putting an additive in there for fly control or for odor control, that's minimum. That's a, you know, 25 points. in there.
That can be discontinued after approval at any time.
Yes, but I mean, you can use it to get in there, but it's not going to get you much in there. Level 2, that's a little hard one, but I went back up to level 1 to look at the other side.
Level one should be,
All of them?
well, level one ought to be what you've got there, which is actual vegetation,
Yeah.
barriers, wind breaks, whatever. It should also be having a dry manure storage barn.
Okay.
That's a big thing. Let me tell you, my neighbor's one, he went from 2 houses to 4 houses and put in a dry manure storage thing, and it smelled better with 4 houses than it did with 2. With having a shed out there, putting that stuff in. That made a huge difference. So I mean, that ought to be highly, people ought to get a lot of points for it, is what I'm saying. It's a very effective odor control method.
Compost facility, not only for dead animals, but also manure.
Right.
All right. Level 2,
Electrical, I don't know what else people really do.
well, they get some here, they said,
Yeah, but what all was that? Is anybody around here actually doing that stuff?
well, they got
Can you?
anaerobic digester. That's expensive.
Yeah, nobody's gonna do
That's the deal with liquid
that.
manure.
Yeah.
Would incorporation enter into that?
We can't, land application, we have no jurisdiction.
The state of Indiana takes care of that. We have no,
Okay.
not in this state. We can't do anything with that application.
Good idea, that would be one, for incorporation would be good, but we don't have jurisdiction over that. We gotta deal with a site location and that site.
What about the direction the fan is blowing?
They have to go out in all directions. You can't, see, that's the thing, those houses, they've got to have so many fans in so many places blowing out. And they're all controlled by temperature sensors inside, because the sun moves, see? And the sun is not always shining in the same place on the building, so they're actually, those fans are not arbitrary. There's actually sensors in there that make them turn on and off to keep the temperature right.
And I know what you're talking about as far as the tunnel ventilated buildings where your primary fans on, his fans that he's talking about, a lot of the newer buildings have multiple fans
Yeah.
down through there to kind of zone that building. But like the bank of 8 fans, the 48-inch fans that you're talking about, I agree with you on that. Say that you have it on the end where it has the least residential or public impact. I can show you several buildings that we would make a huge difference.
Do they still even make those though? Do they still even do
Yeah.
it that way?
Yeah, they do have a combination. they use the tunnel ventilated fans, and then they use these multiple fans for zone.
Right, but even the tunnel ventilated fans turn on and off and.
Oh, yeah, yeah, that's all regulated.
Yeah.
But it's still your primary airflow exhaust where you're talking about. Compared to, I've got my exhaust fans shooting right at a residence across the road, or if I got my fans, my primary fans on the other end of the pasture field that open to 40 acres.
That could be like a level 2 or something, fan ventilation orientation.
That's what I was thinking.
That's
what I was thinking.
all right.
But if it's not applicable, it's.
Yeah, I don't know. If you think it makes a difference, you probably know as much about it as anyone.
Well, let's go back to Dr. Ebert's model, computer model. I mean, wind and, because that's another thing is, you know, as far as, is the structure going to, is a facility going to be placed southwest of a resident or northeast of a residence? You consider the general, not always, but generally which direction is the wind blow. And that might have some impact. And I thought he talked about those types of things in his model, was wind and direction of discharge.
He did. Good ideas, we thought it was too complicated to put all those variables.
Yeah, and to adopt his precise formula into an ordinance.
But there's points there.
But my question is, because if that's the goal, and his ideas were well taken, that these are the things, these are the very factors that increase or decrease nuisance to neighbors, then is there a way to work that concept in?
We've tried to make this score sheet so that somebody like Irvin goes out with a client and they look at a piece of property. And so, can we say in this county that we have a prevailing wind direction? Jim?
Usually comes out of the west.
All right, usually comes out southwest. Okay.
Most of the time, yeah.
All right.
More days
So-
a year than any other direction.
How is Urban going to quantify that wind direction as being a level 2?
Oh, picky.
I know, but that's where it is.
Yeah, I know.
Yeah. Should we even have level 2 in there, or we should just have level 1 and level 3? Or start level 1 and level 2 and do away with level 2? Like level 2, level 3?
Well, I tell you what, let me do it this way. Level 2 is one of the top 3. The level 1 is green barrier, compost, manure, dead end.
Right.
Level 2 is implementing 2 of those.
Level 2.
Level 2 would be,
Oh, I got you.
A second.
I got you.
yeah, would be implementing at least 2 of those.
Or at least one.
Or at least
A
one.
second. At least one. See what he's saying? If level 1 includes several different things, level 2 could just be doing at least one of the things in level 2. See what I'm doing? One of the things in level 1.
Who's on first?
Yeah, well, I know, but level 1 is the ultimate, okay, and that's what we want.
Like these oatmeal raisin cookies.
Yeah,
So,
all right,
There was some oatmeal.
trade these out.
I'm losing you guys. Level 1 is the green barrier, compost, manure, compost for dead ends.
So basically, you want that to be barriers and compost and dry
Is
manure
level
storage
1.
facility. Right,
Yeah.
and all of it is level 1.
Yeah.
One of the things in level 1 is level 2, and then level 3 can be, your feed additives and fan orientation and, things that really don't make much of a difference.
Or maybe we don't get too married to the idea of level 1, level 2, level 3, and just say, let's rank those. Which ones make the most difference? Like all these other factors, and assign an appropriate level of points. Because the level 1, 2, 3 probably came from a system, and correct me, Daniel, if I'm not saying it right, where there were multiple variables, and if we've only got a handful,
might as well just make it.
They just say, you know, this one's worth 50
Right.
points,
Dry
this one's
manure
worth
storage
68
facility,
points.
right.
Just relative to what it's.
I think that's
Yeah,
more
that's-
sensible.
that-
Do it that
I don't
way.
mean to undo what people have done.
But it makes
by
way
any
more
means.
sense.
I think it
But let's not get stuck in the mindset that because we started out considering that.
That'd probably be simpler.
Yeah,
right.
yeah, just say.
But I can see if there were, if we had 8 different things that were about the same abatement, and 8 in each category, there were 24 different ones, 8 of them might be in level 1, 8 in level 2, 8 in level 3.
Right.
But
We're just
if
dealing with
if
it.
we've got only a handful of,
Couldn't agree more.
Do you want, like level 1, would you want 3 things implemented, multiple?
He's saying just do away with the level.
Do away with-
I'm just saying, how many points?
So what do you want to give for a maximum points? 100 still? Okay,
Say 100 points for a dry manure storage facility.
for the one thing that you do.
Or 70 points or something. You see what I'm saying?
Well, what I was thinking is about 33 and a third.
You see what
And if they do all 3, they get 100.
Yeah, that's right.
Right. Or you could round it off to 30.
33 or 35.
35,
You
yeah.
get adjusted to it,
Yeah.
you know. Really, I think the green barriers, compost, whether it's manure, that probably had the biggest odor impact
Absolutely.
of any of them. So those would be classified as 35-point items.
Okay.
And then just classify each item. I mean, it's not going to take much more lines than writing level 1, level 2, and level 3.
All right. So diet formulation would be
25-point item.
If we're only giving 30, if we're giving
Yeah.
35,
Yeah, that's
that's
true.
about a 6-point item.
I wouldn't give it any more than 10.
Yeah.
Yeah, see, that's why I think those other 3 ought to have more than 35. I think if somebody does, see, if somebody did 1, you can give them 50 right there.
But then you make this score too easy.
You think?
Yeah. Well, the thing about it, homestead exemption has probably the biggest impact. But the odor abatement was the catalyst to get them over the hump. And that's the one we want to promote more.
Right, so diet 10 points, okay. And that just covers everything. We don't need to worry about anything else. If we do, we'll just put it in there and assign some points to it.
All right, I'm going to mark on my paper here. Let's go to dry manure. If you got this chart in here.
Yeah.
Right now.
See, the top one, he's got storage practices.
All right, so that's the
the top
35.
That's the top one. Then you start down with, impermeable covers, composting, diet, landscape, and additives at the bottom.
Right. Impermeable covers would be a dry facility.
Right.
Filled in.
Dry facility. That's what I'm talking, it's all dry.
That's,
Those are 35 items, right? We thought about 35.
yes, he's giving us 50 to 80% there. That's a big percentage.
All right, do we want to do that as far as scoring in there by similar to that? All right, let's go down through your covers. Is that 35?
That's the bill now.
If I get the strongest one.
Take that, put that 35 right there.
This one?
Yeah.
Impermeable covers.
Yeah, composting, same thing, 35.
I think we need to define these, because what I consider an impermeable cover and what I consider covered composting is 2 different things. You know what I mean? Like when we talk about a green barrier, my definition of a green barrier is probably different than yours.
Right.
And so that's, I guess, where I'm having a hard time
Well, it does need to be defined.
grabbing some of
The
what we're
definition.
saying.
And the impermeable cover is not, we're not talking about throwing a tarp over your pile of poo out there either. We're talking about a building.
Okay.
You know, that's why I wouldn't use their language, I just write it the way we've got it.
Okay.
See what I'm saying? No, it is called a dry manure storage building.
All right.
And that's,
All right, diet, that we said 10. Landscaping, that would be your lower foliage that you would have. That's more aesthetics than anything. That would be the difference between a green filter and barrier
be something that's ongoing. It may take a while for your greenberry
Right,
to
oh, yeah.
reach
But if
the
you,
required height.
if they've planted pine trees, you know they're gonna get big.
Yes.
If they've planted tulips, you know, you can pretty well cross out what's obviously not gonna work with a green barrier.
All right.
But a green barrier should be defined as vegetation that will reach or exceed, 30 feet in height.
All right,
And
let's go back in there. We talked about composting on dry manure. Let's look at liquid manure. Because not all poop is created equally.
right.
Something, compost that would be, same would be your anaerobic digesters. So they need to be weighted the same amount of points as what a compost.
Okay. Now, liquid, obviously it's gonna be kept in a tank regardless, isn't it?
Could be a lagoon,
People do all that, that's true.
but you're not gonna build a lagoon in Indiana. That's not gonna happen.
I didn't want to pass that down.
Yeah, we're already past that.
Yeah,
So they're gonna be in pits.
So it's gonna be in a tank regardless?
Be either underground tank or it'll be in a, you can build a concrete, structure outside. It's not covered. You can have a harvest store or a slurry store, but you cannot build a earthen lagoon unless it's lined. And the thing about it, I guess you can, I haven't known of any livestock operations putting in a lined lagoon because of cost of it. That usually happens in municipalities. All right, so, but what I'm getting at, compost and dry manure, anaerobic digester for liquid would be comparable.
Yeah.
Your barrier, green barrier is going to work the same, whatever operation, but because of your manures, that's going to be comparable. And that's probably the only, more feed additives is going to be the same between the liquid system or a dry system. So still,
And the
same amount of-
vegetation is going to be.
yeah, so that'd be the same. So that anaerobic digester, would be one that would be comparable. All right. Well, can we put a list together and put points in there? Now, you want to give them maximum points, or you want to allow them to infinity? They could pass this whole thing by just implementing.
My suggestion would be that if there's multiple ones, it's kind of like you learn in band class, band, if a trumpet is blowing at a certain decibel level and the next guy starts blowing his trumpet, the added volume isn't double. Each incremental increase doesn't increase the offense by the sum of the number. So it's kind of like if someone implements one, is it safe to say that implementing one has a profound effect, or alleviating the smell? The next one, if it were implemented alone, would have a profound effect. But if there's a greater one already implemented, it's not going to have as profound an effect. There's going to be, that's why I'm asking, is it safe to say that? If
No, I
not,
don't think it is.
Okay.
It's like the green barrier is a totally different kind. It's doing a totally different thing than what keeping the manure dry is doing. The manure being dry or wet is going to smell better or worse, respectively. And having the green barrier there is going to make that particular smell of either one that much better. So,
The way I look at it,
I would
our
say-
point system in there, we tested it for the scores in there, and our numbers, like 100, 50, and 25, as we went through the different scenarios, showed impacts of them implementing at those different levels. So I think that we get to a point of maximum score of 100, and the 2 is down below, so, we showed that the impact of 100, if you implement so many of these things to get up to a maximum of 100, it's going to have enough impact to bring you up to level for it to meet the minimum score.
Right.
So take the levels all out, the maximum 100 points. What about that?
Yeah.
And then we score each one of the systems differently so they can stack it to whatever, to get up to 100. But 100 is the max.
Now, how many points did we give for what the on-site operator residency?
100 points.
Okay.
A lot of people thought there was a lot of public.
I understand that, but
I know it's a.
that's two different things. What's most important and what's equal?
Well, these two are the big swings.
Yeah. Which would you rather have? Someone who lives there and implements none of these, or someone who implements 3 of these odor abatement practices but doesn't live there?
Under the, all these,
Implemented.
Yeah.
So you see what I'm saying?
That's what I do.
Let's just, and I know this is an imprecise process, but I think that dictates that maybe we decrease the on-site residency
Yeah.
and say, okay, maybe, and then maybe up to 120 for odor abatement maximum. These odor abatement.
Well, you got your different scenarios. You're dealing with you've seen, and Tom, you don't have all these in there. But we did these points in there.
And if I remember right, in those scenarios, the one thing we didn't have was knowledge of what odor abatement practices
Right.
may or may not be
But
in place at the time, and that when we first addressed this.
See, a homestead award, we lowered it to 50. We had it on 50 before, and boy, those really made low scores on some farms. It really lowered the scores.
I know the homestead score is not the fairest thing out there, and you would rather see people do, but I don't think that, I mean, a lot of people would have to do both. They don't have the homestead score and.
Well, I think that's,
some form of odor abatement just to pass the thing.
I think that's what we come to the conclusion when we practiced it in areas that they were going to have to do multiple,
Yes, yeah.
you know?
I don't see a problem with that.
Yeah.
Right, but what I'm saying is that the homestead thing, the only reason I've argued in favor of it the whole time is because a lot of people.
I'm in favor of it too.
Right. Just how much weight we're putting on.
I'm just saying, I just suggested a relatively minor adjustment to the
Right.
weight in context of what we're talking
I
about
mean,
now.
take it down to 80 points and add 20 more points to the odor abatement.
That's what
As a max.
I think that's a good idea.
And that's all
80
those-
to 120.
And I just pulled those numbers out of there. We could make it 15 each way. I don't care. I'm just saying, let's think about this. Would you rather have someone live there and have no odor abatement practices, or someone live in another state and have all these odor abatement practices? And if we cap it at 100, these odor abatement practices,
Right. I see
that
what
might
you're
not
saying.
be as smart
All right.
thing to do.
I'm gonna throw a little piece of metal into the gear.
Okay.
Okay? This is the hardest thing for us to regulate, is odor abatement.
On an ongoing basis.
Right.
As far as,
Initially too. You got a site that goes up, and they say they're gonna put vegetation. Building's already up and operating. And they said, well, we're in the process of the vegetation.
Well,
So then what are you gonna do with the
to
operation?
follow through with that thought, we would have to write legislation into this thing for punitive measures to be taken against those doing that in a timely fashion, which we're getting into a whole other, you
Yep.
have to start carrying a gun and a stick.
All right.
I mean, obviously, whether it's whatever the ordinance may be, there's legal action for a reason.
Right.
And injunctive relief, shut down operate, seek a court order that this has to be done, or you face this penalty or
Right.
whatever.
But wouldn't our ordinance need to say for that? I mean, wouldn't it need to say, hey, you know, this is there's gotta be teeth in there
Well,
somewhere.
and inherent in, I just happened to come across this the other day when I was reviewing some local government statutes. Inherent in the power is the right to pursue in court.
Right.
I don't remember if it's generally in reference to a specific statute, but yeah, it doesn't hurt. We've done it in other instances. We've done it in the subdivision, we do it in the subdivision, in the building code. You know, if someone doesn't, we do that in several of our ordinances, so.
Right. A little language to that effect would be a bad idea.
All right, I want to be out here by 9.
We're gonna have to make a motion here to put all these changes in the record. So moved.
You want to go ahead, I think that what I need to do is get these strategies and start listing them and try to put points, against them. The next time we look at it, we can say, this is good, 35, 35, 10, 10.
And then let me get with Danielle instead of you on some of these language changes. I mean, who has the running draft on a computer?
I've got, this is what I've done on the computer right now with those changes in there. I've gone in there and pulled a little format off to the side. I've made some notes.
Track changes.
Track changes.
Okay.
In that, and I've got this one proof of water in there. My track change out, throw it to you, let you look
Let's
at
do
it.
that.
All right, I really wanted to put something together, put a draft together, kind of move this
I
thing
think we
through.
just about can just put a draft together. I think it's all just putting this thing.
And I think that what we
language
should
right
do
there.
is bring 2 versions to each, I'll email out 2 versions to each person. One with all the track changes, and then one with all those proposed changes accepted. So that some people have a hard time reading the track changes version, you know what I'm talking about, where it's got the cross out.
Right.
You know, but at the same time, someone like me, you just send me a version without the track, I don't know what you changed, what did the last one say versus this one.
Precisely.
So I like to see both what was changed and then how does it read now without all those marks.
Or just the original copy and the new copy.
I've got some track changes
By
already.
section.
There hasn't been too many, I'll try to get that to you, Tom.
5 or 7 years.
Okay, all right, let's, need to put points on those things. All right,
Well, I'd say, you got 35, 35, and 35, so that's 105.
right,
And then 10, that's 115.
yeah, but there's other ones in here that I think that we could probably. There's
Not
not.
really anything else. That's 115, we could knock the homestead down to 85, and that would define the number right there.
I think we need to vote on that. We
Yeah.
voted as a commission at the last meeting to accept 1B with the changes that were made.
That's what I was making the
Okay,
motion to do.
I want to make sure.
All right, we have a motion on the floor, you want to make that a motion?
I did.
Okay, he makes a motion on the floor to change homestead to 80 and bring up odor abatement to 120.
Well, that'd be 85 and 115. That was my numbers.
80 and 115, 85 and
85 and 115.
85 and 115. Motion, do we have a second? Jerry McCollum, second on that. Any more discussion? All in favor, please signify by hand, the right hand. All in favor, signify by your right hand. All opposed, same. Passed. 85 and 115. On the point system. Okay. Now, we have a motion to go ahead and allow draft changes, to tweak this language out. For the discussion.
I make a motion that all of the changes that we discussed tonight are to be put into a draft.
Okay. Have motion to put draft language together on all the changes tonight. Do I have a second? Jerry McCollum, second. It's open for discussion. Seeing none, do I have a vote again? All in favor, signify by raising your right hand. All opposed? Passed unanimously. Make a remark that Jeff has left and wasn't, even though he was present in attendance, did not vote because he was not here. So it was not a thing vote. And I tell you what, there's some information that's missing that not everybody has. And I guess for reference, I'm gonna try to, we'll update this 1B and try to get this scenario out to you with our changes all in that, so you can see the score sheet. And then, Tom, I'll send you revision, what change formats I've got, plus I'll go back and tweak this other stuff in there and try to send it to you in that format. It's got the original language, but it just had line down and changes.
I'll second that too.
Second that. So,
That's from the copy.
yeah, wait, that's for you.
If anybody wants to show monetary gratitude to Ron Green, snack, I think that would be.
No,
Or a cookie.
I am not a food prostitute, okay? I had to get out of here, and then there were cookies, and I thought, shoot, if I buy one.
They'll say,
You got plenty to take home with you.
Okay, do I have a motion to adjourn?
Yes.
A second?
Second.
All in favor, stand up. All right.
Now, Rhonda, does that mean if I want to get out of here, all I need to do is go around and get cookies?
Yes.